The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. This is Tony Franco, partner at PilieroMazza, starting the seminar on the 8A Business Development Program, getting certified and staying compliant. Before we proceed, we do want to thank our media sponsor, Set Aside Alert. We thank them for all the support they've given us and the support they give to the small business community through their publication and the information they convey on what is going on in the world of set-asides. This topic that we will be discussing today during our webinar in the 8A Business Development Program and how to get certified and stay compliant is one that we chose because we have so many clients that and potential clients that call us because they are seeking 8A certification and have so many questions about the process. And many of our clients aren't in the 8A program, and once they enter the program want to make sure they stay compliant, particularly in the environment in which we are living in these days where there is a significant amount of contract audits and investigations of firms in the government contracting arena. And so we help many of our clients and their teaming partners who want to make sure that they're teaming with companies that are compliant with the 8A program rules. Our presentation today will be given by me, a senior partner in the government contracting group at PilieroMazza, with my colleague Peter Ford. Peter and I have worked on many 8A applications over the years and also helped many firms that have been admitted into the program navigate this highly regulated world that is 8A government contracting. During the webinar today, we are going to basically discuss how to apply for the program in very general terms, since we only have an hour and we do want to take questions and answer to the questions towards the end of our webinar. But we do want all of you who are attending to understand what the process entails, both in terms of the eligibility criteria and understanding the application process itself. We then want to go ahead and segue into maintaining 8A eligibility, because once you enter the program, there are some very strict rules that have to be followed. And whereas in the past, the SBA was not particularly strict with regard to holding firms accountable that may have run afoul of the rules or may have become ineligible to continue participating in the program, we have found that there's been a real change in climate there. Many firms are being suspended from the program and are terminated early or graduated early. And so it's critical that firms know what the rules are and what they need to do to remain in good standing or eligible as long as possible to the extent the program is continuing to provide them with benefits. And to this day, we do see many companies that are being approached by contracting officers telling them, well, if you were 8A certified, we'd be able to steer more work in your direction. Because those goals are so important for the agencies. We will conclude the presentation by sort of giving you discussing some topics that we see on the horizon that 8A firms and small business in general should be aware of. And then we will go ahead and take questions from the audience. And to the extent we can't go through all of them, we will be following up after the webinar from our office. Peter and I will send back email responses to those of you who we can't get to today. Turning then to the first slide, we're going to just segue into preparing for a smooth certification process, and Peter's going to go ahead and take it from here.
Okay, so the first step, of course, is making sure that you meet the eligibility criteria. So what are the basic criteria for 8A program eligibility? Generally, a concern meets the basic requirements for admission to the 8A program if it is a small business which is unconditionally owned and controlled by one or more socially and economically disadvantaged individuals who are U.S. citizens of good character and the firm demonstrates potential for success. We'll devote the next 15 minutes or so to explaining what these criteria require exactly. So first, as this slide shows, you have to be a small business. And you have to be small in your primary industry classification, that is your primary NAICS code. In determining size, the SBA will combine the revenues or employees of an applicant firm and its affiliates. There are a number of affiliation rules and tests, affiliation based on stock ownership, common management, shared identity of interest, etc. However, under any affiliation analysis, the key is whether one firm controls or how it has the power to control another firm, or a third party controls or has the power to control both firms. Notably, firms owned by tribes and native-owned firms enjoy somewhat relaxed affiliation rules, but they are not immune to a finding of affiliation. So this next slide pretty much sums up the basic eligibility criteria in addition to being a small business. And just to quickly reiterate, in addition to being a small business, an 8A firm must be unconditionally owned and controlled by socially and economically disadvantaged individuals who are U.S. citizens of good character, and the firm must demonstrate a potential for success. So who is socially disadvantaged? Socially disadvantaged individuals are individuals who have been subject to racial or ethnic discrimination or cultural bias in American society due to their identities as members of groups. And in our experience, proving social disadvantage can either be relatively easy or it can be very difficult. So what do we mean by that? Well, there's a presumption that members of certain groups are socially disadvantaged. These 5 designated groups include Black Americans, Asian Pacific Americans, Hispanic Americans, Native Americans, and subcontinent Asian Americans. If you are a member of one of these designated groups, you may just need to check the box, so to speak, to prove social disadvantage. However, SBA can, and often does, require that you provide evidence that you are and you hold yourself out as being a member of a designated group. And this might include a birth certificate or possibly letters from friends and colleagues attesting to the fact that you have always held yourself out as being a member of that designated group. So what happens if you are not in a presumed minority group? If you're not a member of a designated minority group, you must prove to the SBA by a preponderance of the evidence that is more probable than not that you are in fact socially disadvantaged. So how does this work? Well, as part of your 8A application, you're going to be required to submit a written narrative statement within which you are going to describe specific examples of discrimination that you have faced in American society. The discrimination must stem from an objective distinguishing feature, for example, a physical handicap, and the discrimination must have negatively impacted your entry into or advancement in the business world. For example, the discrimination resulted in you not getting a promotion or a contract opportunity. Generally speaking, the SBA is only concerned with discrimination that you have been subjected to during your educational, employment, and business history. And in reviewing a social disadvantage narrative, there are certain things that the SBA looks for over and beyond the existence of an objective distinguishing feature and negative impact. For example, the SBA considers the number of incidents and the specificity and significance of each incident, as well as the credibility or believability of the incidents described, and, if applicable, the existence of evidence which may cast doubt on a particular claim of discrimination.
Now, we're moving on to establishing economic disadvantage, but just before we move to the economic disadvantage slide, I do want to highlight that the proving social disadvantage for individuals that are not members of a presumed disadvantaged group, is very difficult. But there are more and more people that we are seeing that are trying to enter the 8A program. Many women, many service-disabled veterans, people who traditionally are not viewed as eligible for the program are trying to get in. And the SBA, if they see that you have a very strong and convincing story, not only based upon your narrative, but also supporting narratives from other people who can vouch for the experiences you've had that prove that you've been discriminated, and that you can show how it has impacted your ability to succeed in the free enterprise system, those are the individuals that are more likely than not to be able to get into the program. And now, with regard to the next slide on who is economically disadvantaged, there are 2 basic rules here that we want to make sure the audience is aware of. The one rule that most applicants know is that there are limits in terms of your net worth and personal income, and those are laid out in the slide. I'm not going to go into those because they're right there, and our audience can read them. One of the new rules that the SBA issued is that they will also not find the firm eligible if the total assets of the of the company applying for the program, including the individual upon whom eligibility is based, exceed $4 million. It doesn't matter if that business is highly encumbered or the owner is highly leveraged. They're going to just look at what are the total assets, and if they exceed $4 million, you will not be eligible to enter the program. With regard to the first slide, though, regarding social disadvantaged individuals whose ability to compete in the free enterprise has been impaired due to diminished capital and credit opportunities, we always put this in any presentation involving applying for the 8A program because many people who are in presumed groups assume that if they meet the economic disadvantage factors and are able to essentially check the box as being part of being one of these groups, that they are eligible. And they make a big mistake when they do that if they don't keep in mind that they need to provide the SBA with a narrative statement of their own that explains how it is that they've experienced discrimination and how that's impacted their ability to compete in the free enterprise system. And so it's important for those of you who are considering applying for the program that you not just view the process of one of giving the SBA financial data and trying to establish how you meet the economic disadvantage criteria through your income tax returns and financial statements, but also that you need to come up with a good explanation and story as to what has happened to you in your life that has made you economically disadvantaged. And oftentimes we see folks that have come up with some canned responses that look very mechanically drafted, and it's important for people to personalize them and to go into some details with more than one example of how it is that they were the victims of discrimination. Keep in mind, too, that for those of you who are thinking about applying for the program, there are exclusions that are not taken into account in determining net worth for an individual. That is, for example, they're not going to consider the value of your home and your business. So the value of your home and your business is not going to count against your personal net worth benchmark. And with regard to personal income, one of the things the SBA will not look at is to the extent that you're taking money out of your company to pay taxes. That is, or money that appears to be taken out, but in fact is being reinvested in the company. That will not count against you in determining your 3-year average. Now, one of the other very important areas that we focus on when looking at 8A applications is just a rule that essentially requires that the individual upon whom eligibility is based have unconditional ownership over the company. Unconditional ownership, really what the SBA here is looking at is whether the individual has direct ownership that can't be normally owned through another company that individual has. They can't have a trust, but that trust has to be revocable and they have to be the sole beneficiary, and there are certain very strict rules regarding how it is that ownership can be held. You know, most people are applying based upon their direct ownership, but they must own 51% of the company. And what the SBA is looking at here normally is the shareholders agreement, operating agreements, those agreements that are normally entered into by people in the business world that have partners. And many 8A applicants do have business partners, and they need to be aware of the fact that the SBA will look at the governing documents that need to be submitted for the company in order to see whether there's any provisions in there that somehow limit the ownership and control of the individual upon whom eligibility is based. And this is the reason why the SBA requires that applicants submit their articles of organization, their operating agreement, their shareholders agreement, and their bylaws. Another thing that the SBA looks at is whether the individual owns the majority of all kinds of classes of stock, and whether the individuals that are minority owners in the company, meaning own less than 51%, whether there's any way that based upon the agreements they have with the majority owner, they could ever increase their shares, because the SBA gives those essentially unexercised stock options or agreements that will allow non-disadvantaged owners to acquire more shares as if that had really happened. And so many owners don't realize that if they've indicated to the minority owners that in 5 years they're willing to give them the majority of the company, that may actually automatically disqualify them. And the SBA will also look to see whether the governing documents show that how distributions will be made. That there's nothing that would suggest that the individual upon whom eligibility is based is really a front for someone else who will really reap all the benefits of participation in the 8A program. And those of you who are in attendance who live in community property states should be aware of the fact that when you apply for the program, you will need to have some kind of documentation submitted that will show the SBA that your spouse will not be able to assert rights over the company, because it's fairly clear that the individual upon whom eligibility is based owns it without there being any conditions on that ownership. Now, one of the areas that we oftentimes see many of our clients come to us to apply for the program is when they had a family member that had been in the program. Or oftentimes there's a person who's done very well in the program and they want to encourage a sibling or a son or daughter to get in the program. And the SBA frowns upon that. There is essentially a prohibition on ownership in 8A firms by immediate family members. And that prohibition actually extends to even in situations where a individual is applying for the program and an immediate family member is no longer in the program but was in the program. So if an applicant has a family member that was or is currently in the program, they're going to have to seek a waiver from the SBA in order to apply for the program. And one of the things that the SBA focuses on immediately is whether the two companies at issue here, owned by the family members, are in the same or similar line of business. When two companies are in the same or similar line of business and they want to be in the 8A program, or one of them was in the program and another one wants to follow up, the SBA starts questioning whether that really isn't just contrived in order so that one family has essentially a dynasty in the program. And so in order to be able to get the waiver, you need to show that the companies are really in separate lines of business and they have no connections. And there is a presumption against granting that waiver. And assuming the waiver is granted, those firms that do enter the program that had a family member and the program, and they had a family member that was in the program, they need to not do any business together in the future, because if the SBA finds out that you're doing business with that family member's company, you could get terminated from the program, because the SBA will grant the waiver in anticipation that you're not going to do any business with that company. Now, another area that we often see many of our clients looking into is, what are the exact rules that apply for non-disadvantaged individuals who want to invest in 8A companies. And there are a lot of individuals out there who've seen how the program works and have wanted to help the disadvantaged individuals, and that the SBA views those situations as ones that could be abused. So therefore, they do place limitations on how much a non-disadvantaged individual may own in more than one 8A firm. One of the biggest issues they look at is whether these individuals also happen to have interest in another company that's in the same or similar line of business. And more often than not, when we're dealing with these situations where someone wants to buy a minority interest or owns a minority interest in an 8A firm, if they have an interest in another company, it's often in one that's in the same or similar line of business, and that then raises a bunch of red flags. If they're not in the same or similar line of business, you're not going to have the same restrictions that the regulations provide for, but nonetheless, they are going to be very, very carefully scrutinized. And you should be aware of the fact that under the regulations, firms that have participated in the program may have ownership interests in firms that are current participants in the program. The rules are somewhat relaxed in terms of the percentage ownership as laid out in slide number 12, depending on whether the 8A firm is in the developmental or transitional stage of the program. But again, that is a rule that applies where the companies are in the same or similar line of business. If they're not in the same or similar line of business, the restrictions are not as onerous. Now, moving on to unconditional control. Peter?
Yeah, so just quickly, one of the things that Tony mentioned as far as proving unconditional ownership is that the SBA is going to be looking at your governing documents. And a lot of times, to build on that, a lot of times firms get confused as to why is the SBA asking for all of these documents, over and beyond, your bylaws or your operating agreement, why do they want to see, copies of contracts? Why do they want to see, your stock ledger? And a lot of times, more often than not, in addition to it being an ownership issue, they want to make sure that this company is in fact controlled by a disadvantaged individual. So turning to control, what is control? Control is not the same as ownership, although both may reside in the same person. And under the SBA's regulations, control includes both the strategic policy setting exercised by boards of directors and the day-to-day management and administration of the firm's business operations. In this regard, the disadvantaged owner is required to possess managerial experience of the extent and complexity necessary to run the firm. However, that owner need not have the technical expertise or possess a required license if he or she can demonstrate that he or she has ultimate managerial and supervisory control over those who do possess the required licenses or technical expertise. With that being said, if all of your managerial experience stems from running an IT company, the SBA is likely going to question your ability to control an applicant firm whose primary industry is construction, which really has nothing to do with IT. So what does control require? To establish control, a disadvantaged owner must manage the firm on a full-time basis, and this also means that that owner must refrain from engaging in outside employment without the SBA's prior approval. The owner must hold the highest officer position, usually president or CEO, and he must be the firm's highest compensated individual, although there is an exception that allows a disadvantaged owner to elect to take a lower salary if he or she can demonstrate to the SBA that doing so essentially helps the firm. And for partnerships, the disadvantaged owner has to serve as the general partner with control over all partnership decisions. Similarly, for an LLC, he or she has to serve as the managing member with control over all LLC decisions. And for a corporation, that individual must control the board of directors. The SBA does recognize and permit certain minority owner protections in the form of supermajority voting requirements. However, the permitted minority shareholder protections are quite limited, and they include, for example, a supermajority voting requirement to amend a corporation's articles of incorporation or its bylaws, issue new shares of capital stock, or enter into a new and substantially different line of business. So, similar to the SBA requirement that a disadvantaged owner has to control the firm, the SBA's regulations also prohibit control by non-disadvantaged individuals or entities. So this slide kind of just gives you an idea of some of the situations where the SBA will find impermissible control by non-disadvantaged individuals or entities. For example, where a non-disadvantaged individual controls the board of directors through majority voting, which would be affirmative control, or that individual has the ability to block board quorum or board action, which would be negative control. Also, where a non-disadvantaged individual or entity provides the firm with bonding or financial support to the extent that that individual has significant influence, not necessarily absolute control, over the firm's business decisions. They also might find impermissible negative control where there are loan arrangements between the firm and a non-disadvantaged individual or entity, although providing a loan guarantee on commercially reasonable terms may be okay. And then lastly, where business relationships between the firm and a non-disadvantaged individual or entity exist that prevent the exercise of independent business judgment without great economic risk. For example, where an applicant firm derives essentially all of its revenue from a single non-disadvantaged entity, or where an applicant relies on a non-disadvantaged entity for all financial capital, facilities, and equipment to perform its contracts, SBA might conclude that the applicant firm cannot exercise independent business judgment without great economic risk. So potential for success. So what is potential for success? Well, the SBA's regulations require that an applicant firm possess reasonable prospects for success in competing in the private sector if admitted to the program. And to do so, right off the bat, it must be generating revenues in its primary industry for at least 2 full years as evidenced by income tax returns. So what this means is that this 2-year clock does not necessarily start running on the date that you form the company. Rather, the clock starts running once you start generating revenues. The SBA can waive the 2 years in business requirement, and that requires that the applicant submit a 2-year waiver. And in this 2-year waiver, you need to demonstrate that the disadvantaged owner has substantial business management experience, that the applicant has demonstrated technical expertise necessary to carry out its business plan with a substantial likelihood of success, that the applicant has adequate capital to sustain its business operations, that the applicant has a record of successful performance on contracts, either governmental or non-governmental, and that the applicant has or can readily obtain the personnel, facilities, and equipment necessary to perform contracts as a participant. And again, I mean, to meet the waiver, you have to meet all 5. So turning to potential for success, again, assume that you do meet the 2-year in business requirement. What else is the SBA going to be looking at as far as assessing a firm's potential for success? Well, one, they're going to see what is the firm's access to credit and capital. What is the technical and managerial experience of the firm's managers? What's the firm's operating history? What type of record of performance on contracts in its primary industry does it have? And then what's its financial capacity? And then in terms of financial capacity, the SBA really focuses on 3 items. One is working capital, one is the company's net worth, and one is the company's net income. And again, there is no magic number, for example, for working capital, because obviously the working capital necessary to run a consulting firm is going to be much less than what's required to run a construction firm. But at the end of the day, going into the application process, if you want to succeed in proving to the SBA that you have potential for success, one, working capital, net worth, and net income should all at least be positive. And if the SBA sees any sort of downward trend, for example, they're looking at a 3-year history and they're seeing that, 3 years ago you had pretty good working capital, but over the past 2 years, that working capital has substantially decreased. That may be a reason for the SBA making a determination that the company does not possess potential for success. Okay, so lastly, good character. The applicant or participant in all of its principles must have good character. An applicant is ineligible for the 8A program if the firm or its principals lack business integrity, as evidenced by guilty plea, conviction, civil judgment, settlement, etc., or if the applicant or its principals is currently incarcerated or on parole or probation following the conviction of a crime involving business integrity. It's important to note that not all crimes necessarily impact integrity. For example, a DUI charge may not lead to a finding of a lack of good character. However, commission of fraud, breaches of trust, embezzlement, false claims, and false statements likely do impact business integrity. And lastly, as you can see, if you knowingly submit false information to the SBA in connection with your application, or if you or the applicant firm are currently debarred or suspended from government contracting, the SBA is going to deem you ineligible and deny your 8A application.
Now turning to understanding the applications process itself. Normally when a client comes to us and wants to apply for the program, they have pulled the application from the SBA's webpage or have started drafting and gathering the information and answering the questions, but they start finding that the application is difficult to navigate, especially the electronic application the SBA wants everyone to submit. What we recommend is before you embark on this entire process is, first determine whether you are eligible. Make sure that you've completed the personal financial statement, run it by your accountant or your lawyer to double check whether at the end of the day you meet the economic disadvantage criteria. Also, you may want to run all your paperwork through your lawyers to make sure that there's no negative control issues. At the end of the day, you want to have some feeling that you are the kind of person that should be applying for the program. I can give you an example of one individual that once submitted to me a beautiful binder to review, And after spending several hours going through the binder, I go to the last document in the binder, and the last document, which was a form that the SBA requires that you complete, he had checked that he was not a U.S. citizen. And he did not realize when he completed this great application that he needed to be a U.S. citizen. And sometimes it's things like these that trip people up. And so it's important to first determine whether you're eligible. And then, review the application. And there's a whole process that the SBA requires that you go through the electronic application. And that's basically laid out for you on page 18 of our webinar slide. It's somewhat of a cumbersome process, but once you've completed everything in draft form, that's when I suggest you run it perhaps by your accountants and your lawyers, or if you're working with a consultant. Or, you can always go to a PTAP center, or these procurement technical assistance centers around the country, help small businesses with their applications. They can provide valuable support, particularly for those companies that just have more limited means and can't seek the help of consultants, counsels, or accountants. Now, once the application is completed and you submit it, the SBA normally within 15 days lets you know what kinds of issues they have with the application. And having done this many, many years and worked very, very closely with clients and clients that have used consultants, even with the help of professionals, the SBA always comes back with all kinds of questions. And you need to be ready to answer those questions once the SBA starts posing them. The SBA has in the past asked questions in different rounds. The first set of questions may be 15, 20 questions. I've seen situations where they may ask only a few questions. You answer them, and then the reviewer all of a sudden has spotted a number of other issues, and they ask, after you've responded to the SBA's data request and information request, they'll ask for more information. And oftentimes it's a very, very frustrating process. The reviewers, we have found, sometimes ask for information that has already been submitted. I recommend that anyone who is dealing with that situation just give the SBA the information again and point out that it was in the application, but without really being contentious. Under the SBA's process, 90 days after they've submitted a complete application, they're supposed to get back to you and let you know whether you're in or out of the program. And those 90 days don't really begin to run until you've answered the last of their questions and they've told you that the application is complete. Unfortunately, what's happening, though, in the real world is because of staffing shortages at the SBA and the workload, that time frame is really slipping very, very, very badly. And many of our clients come to us because they've applied on their own or through a consultant, and they feel that their application has now been held up and they want it expedited, and that's very difficult to do. It does happen from time to time, but you should be aware of the fact that it has become quite a bureaucratic morass to go through the process, unfortunately. So it does require some patience, but if you're diligent and continue giving the SBA what they need, you will get in the program if you're eligible. Now, if you are denied, there is a process to request reconsideration, and there's also a process to appeal. And more often than not, we tell our clients really they should request reconsideration rather than appealing. The request for reconsideration process is one that basically allows you to, for all practical purposes, start over again. I've seen clients come to us and they have essentially done the application on their own or using someone else, and there were certain issues that were so significant in the application that requires a complete redoing of the application, and you can actually basically resubmit the application with a lot of significant changes on a request for recon. Now, if you are denied on a request for reconsideration, you do have the right to appeal to the SBA's Office of Hearings and Appeal, but you don't have an automatic right to appeal for every reason that they may give you. It's only certain reasons that are appealable. For example, if the SBA finds that you are not likely to succeed in the program, the SBA's Office of Hearings and Appeal is not going to review that. They basically consider that an issue for the discretion of the SBA. Now moving to maintaining 8A eligibility. Peter?
Okay. So, of course, there are continued eligibility standards. And so essentially you need to ask yourself, or what we're discussing here, what is required to remain eligible for continued participation in the 8A program? To remain eligible, a participant must continue to meet all of the eligibility criteria that we just kind of walked through. In addition, the participant must inform the SBA of any changes in circumstances which would adversely affect 8A program eligibility. And then lastly, you need to make annual submissions supporting your continued eligibility as part of the annual review process. So turning to annual reviews, at the end of each program term year, a participant is subject to an annual review. The annual review requires a participant to submit information to its district office to support its continued participation in the 8A program. So what type of information is going to have to be submitted? At a minimum, annual review submissions include, one, a certification that all the 8A program requirements are met. There's going to be a certification that there are no changed circumstances which could adversely affect program eligibility. They're going to want to see financial information for each disadvantaged owner, which is going to include, one, an updated personal financial statement, as well as that owner's personal tax return information. They're going to want to see a record of all payments, compensation, and distributions made to each owner, officer, and director, and then, lastly, a listing of any fees paid to agents, representatives, or consultants for assisting in obtaining or seeking to obtain a federal contract. And if at the end of the day the district office finds that the participant continues to satisfy the program criteria, they will sign off on the annual review and in turn sign off on your continued participation in the 8A program. So eligibility reviews. Notably, the eligibility of a participant for a sole source or competitive 8A contract may not be challenged by another participant or any other party, either to the SBA or as part of a bid protest. However, upon receipt of specific and credible information alleging noncompliance with continued eligibility, the SBA will review a firm's eligibility for continued participation in the 8A program. And sufficient reasons for the SBA to conclude that a socially disadvantaged individual is no longer economically disadvantaged include excessive withdrawals, insubstantial personal assets, income, or net worth. So excessive withdrawals. First, what are withdrawals? Withdrawals include cash dividends, distributions in excess of amounts needed to pay taxes for pass-through entities, cash and property withdrawals, payments to immediate family members who are not employed by the participant, bonuses to officers, and investments on behalf of an owner. Officer salaries are generally not considered withdrawals, although the SBA will treat them as withdrawals if they believe a firm is attempting to circumvent the excessive withdrawal limitations through the payment of officer salaries. So when are withdrawals excessive? Withdrawals are excessive if in the aggregate during any fiscal year of the participant they exceed $250,000 for firms with sales up to $1 million, $300,000 for firms with sales between $1 million and $2 million, and $400,000 for firms with sales exceeding $2 million. So more on excessive withdrawals. So what are the potential consequences if, in fact, the SBA concludes that you have excessively withdrawn funds? Well, the SBA can do one of three things. One is they can initiate termination proceedings if the withdrawals detrimentally affect the achievement of the business plan or the company's overall business development. Alternatively, they can initiate early graduation proceedings where the withdrawals do not adversely affect the participant's business development. Or lastly, they can require an appropriate reinvestment of funds or other assets as a condition of continued 8A program eligibility.
Now, with regard to remaining economically disadvantaged, once you enter the 8A program, literally the day after you receive certification, the threshold for your net worth goes up to $750,000, meaning an individual's net worth could be as high as $750,000, not including the value of the home and their business, and remain eligible for the program. The SBA also has bumped up the personal income requirements, allowing an individual upon whom eligibility is based to receive up to $350,000 on average in terms of income, adjusted gross income, and continue participating in the program. And the company's fair market value cannot exceed $6 million. The SBA has been enforcing this rule to the extent that It is fairly new, at least with regard to the increased number on the personal income side to 350 and the total assets rule where there's a specific number. That wasn't the case until several years ago when the SBA amended their rules, but the SBA is looking at the annual report submission to see exactly where it is that the individual upon whom eligibility is based sits with regard to meeting this criteria. And this is a very important issue for those clients of ours that have been in the program doing well and oftentimes find themselves bumping up to these numbers. Keeping in mind that the personal income, for example, criteria is one that could easily be reached by successful companies that are S corporations or operating through LLCs where there's significant, pass-through income. And that companies are basically trying to make sure that the distributions are being made to all the owners, and there's situations where we find that our clients would like to pull more money out in order to buy a residence or maybe a second home or make some kind of investment, and these are things they need to consider very carefully, because to the extent that, for example, you're in the 8A program and you want to invest in another company, that investment will now be excluded from your, would be part of your net worth, not excludable. So we oftentimes tell our clients that if they really want to invest in other entities, they should do it through their company. Also, with regard to the personal income, you have to be mindful of the fact that there's also the excessive withdrawal rule, and the excessive withdrawal rule tends to also hamper how much an owner may take out of the company. At the end of the day, because of this 3-year average rule, I believe 350 is the one that participants need to be most mindful of, particularly if they're being very successful in the program. And then, of course, because of the total assets rule, as you grow and acquire more and more assets, you could easily go over that $6 million. But that is a very hard, fast rule that the SBA has established. And so, therefore, you just need to be mindful of the fact that once it looks like you're hitting these numbers, you may be receiving an early graduation notice. With regard to another issue that we think is very critical when you apply for the program is the SBA requires that it approve any changes in ownership or business structure in the company. If you don't seek the SBA's prior approval, they can terminate you from the program. Also, changes in management. The SBA has become very strict in requiring that it be consulted and its approval sought for any changes in management. I mention this because essentially the changes of ownership, business structure, and management in an 8A firm after a firm is admitted to the 8A program have become very, very hot button issues for the SBA. They've always had problems with changes in ownership. You can seek the SBA's approval to perhaps bring in minority owners that have 20 or 30% interest in your company, but that is viewed by the SBA as a change in ownership and requires their prior approval. And it means that you have to submit a significant amount of paperwork to show how that change of ownership may impact the company or may not, and how it is that this change of ownership is taking place. Similarly, if you're changing management, the SBA wants to make sure the new managers are not in a position to impact the individual upon whom eligibility is based ownership and control of the company. So this is an area that now has become a significant amount of oversight by the SBA, and they do that by looking at what you submitted with your annual report. And if you don't disclose it and they later find out about it, they can terminate you from the program for not having engaged in the full disclosure. The next slide here is staying small, and Peter will take that one.
So, I think the first criteria we discussed for participating in the 8A program is that you had to be a small business, and you had to be a small business under your primary industry classification. And to remain eligible for participation in the 8A program, a firm generally must remain small under its primary industry classification. If a firm exceeds the size standard corresponding to its primary NAICS code for 3 successive program years, the SBA may initiate early graduation proceedings unless the firm can demonstrate that its primary industry is changing to a related secondary industry, and that secondary code is contained in that company's business plan as it's updated over the course of the program term, and that business plan also must contain specific targets, objectives, and goals for its continued growth and development under this new secondary industry. As a practical matter, no firm enters the 8A program hoping not to grow. Therefore, in drafting your initial business plan and then making subsequent updates, it's really critical that you identify related secondary industries with larger size standards, as well as your targets, objectives, and goals, and your continued growth and development under these secondary industries, in the unlikely or likely event that at some point, during the 9-year program term, you are going to exceed the size standard associated with the primary industry upon which your eligibility was originally based.
Now, looking ahead, before we turn to the questions, for those of you that are looking to participate in the program, but more importantly, those that are already in the program, we're waiting for the SBA to issue new standard operating procedures that will lay out how it is that the SBA's revisions to their 8A regulations in 2011 are going to be internally implemented. We have seen it, and so we know from just our day-to-day dealings with 8A applicants and the SBA how the SBA is implementing those regulations. But these new standard operating procedures should be issued soon, we hope, and would allow those of us who work with the SBA to see how it is that they're internally processing changes of ownership requests, annual reviews, questions that may arise regarding the excessive withdrawal rule, since these SOPs give the SBA's personnel internal guidance as to how it is to process paperwork and interpret the regulations. We're hopeful that those will also help those of you in the community that need to see exactly what the SBA is doing internally, since the regulations are not necessarily that clear. Also, we're waiting for the SBA to issue regulations on the new mentor-protege program similar to 8A that is supposed to be issued at any point now, although we understand it's still being reviewed within the administration. But this new program, following up on the Jobs Act and the National Defense Authorization Act, basically is going to allow the SBA to create programs like the 8A's mentor-protege program for service-disabled veteran-owned businesses, for women-owned small businesses, for hub zones. And that is going to provide many, many more opportunities to firms to participate in those programs. And lastly, for those of you, looking to participate in the program or already in the program, just be mindful of the fact that there is significant scrutiny being given to all 8A firms. It's not as easy to get in the program as it used to be. Once in the program, you're going to be subject to much more oversight. The SBA will expect you to be submitting documentation on a yearly basis that's accurate and complete, and it's your responsibility to know the rules. And there are significant benefits in the program, but with those benefits, there are these oversight issues that require that firms realize that they are going to be subject to scrutiny on a regular basis. Now we want to go ahead and turn to questions that we have been receiving from the audience. And we've received a number of them. And
I'll take the first one. It seems there are still some questions, and we may have answered these at some point during the presentation regarding the economic disadvantage criteria. So there's a question about, once you get into the program, what happens if you start, amassing sufficient wealth and now your net worth exceeds $250,000? Well, as Tony mentioned, the moment that you get into the 8A program, those initial thresholds for economic disadvantage jump up. So your personal net worth is now going to be, capped at $750,000, and those exclusions for the equity in your primary residence, the equity in the business, and then, as well as if you have funds that are tied up in an IRA, and there is a penalty for taking those funds out of the IRA, the SBA will also exclude those funds.
Yeah, there's another question we have here is, I'm looking to bring in a gentleman as a 49% owner. However, his wife had an 8A company at one time. He was not an owner, shareholder, officer, or otherwise involved in that company other than by marriage. Will that affiliation make me ineligible for the program if I bring him on? No, I do not believe that kind of relationship that existed between the 49% owner and the fact that his wife was in the program would preclude this individual from applying for the program. I don't see even where the affiliation would exist if the companies are really so separate and the 49% owner does not do any business with the wife's company. But the restrictions on ownership that apply to family members would not be triggered by that factual scenario.
There's a question here regarding the highest compensation issue. And again, just to reiterate, the disadvantaged individual, meaning the disadvantaged owner upon whom the company's eligibility is based, generally must be the highest compensated. And there is that exception that allows that owner to elect to take a lower salary if he or she can demonstrate that it's in the best interest of the company. And so there's a question about, whether this rule applies to executive level leadership, and, how does the SBA take into account, if you have doctors on your payroll, or if you have employees who are working in combat zones overseas. And that's exactly the types of things that the SBA's regulations envision. They envision that, even for a company that may just be getting off the ground, I mean, if you're going to be bringing on someone, with an engineering degree, with a doctorate degree, obviously, the fact that they have those degrees, individuals with those degrees, they demand certain salaries. And SBA recognizes that, and if that person is necessary to help this company get going, get off the ground, then the SBA will likely find that it's in the best interest of the company for the owner to take a lower salary. And the same applies to, if you have employees who are working overseas in combat zones. For example, another typical example is if you have people on board who are getting paid commissions over and above their salary. SBA recognizes that those situations, often do come about, which is why they had this rule.
The next question is, what if an 8A owner of 51% LLC has a service disabled veteran, 49% as the other owner? There's really nothing wrong with that. An 8A owner may have, as minority owners, individuals that are in other groups. The fact that it's an individual service disabled should not be an issue. The one thing that I would add, though, is to the extent of the person who is a 49% owner, if they have an interest in another company, for example, if the service disabled veteran owner that has a 49% has his own SDV or her own SDV company, the SBA would then be focusing there to see if there's any affiliation between the two companies, because if they are doing business together and you have an individual who has another company and also owns a 49% interest in the 8A firm, you're going to want to show that that 49% owner has absolutely no say in the 8A company. You want to be able to also show that the 49% owner's business is not doing business with the 8A company, because once they looks like they're doing things that are designed to help another company through both ownership and contractual relationships, you can start having problems.
So there's a question about the furlough, the government shutdown, and how is that going to affect the speed in which SBA is reviewing these applications and getting them through the whole application process. As far as we know right now, the SBA isn't reviewing applications at this point, and they've kind of put the hold on everything. So what that means is that once the government reopens, there's going to be some backlog, and it's obviously going to slow down the process. But to the extent to which whether that 90-day clock that Tony mentioned is going to automatically be a 100-day or 120-day clock, I mean we don't know exactly. But I mean, as a general rule, I guess we could say, is that obviously the shutdown is going to affect how fast the SBA is processing applications.
Yes, and then one of the other questions we have here is how do the rules for excessive withdrawals of the total assets as part of the 8A joint venture? And I'm really not too sure if I understand that quite. How do the rules for excessive withdrawals and the total assets as part? I think the question there is deals with companies that are in 8A joint ventures, and how is the interest that the 8A firm has in a joint venture impact the total assets test. And there's no doubt about it that a company's interest in a joint venture is an asset, and depending on how your accountant has prepared your financial statements, that may impact your net worth. And I'm not really sure how the rule would apply in the excessive withdrawal scenario. But to the extent that an 8A joint venture is joint venture is pulling money out of their joint venture and moving it into their company, that should not raise any excessive withdrawal rule issues. Although that's a question that, to the extent the author would like to follow up with the office, I'm happy to talk it through with them. Next question.
There's a question about, and again, this is going back to economic disadvantage and specifically personal net worth, about, if the equity in your primary residence is excluded, how does the SBA take into consideration a mortgage that you have on that property? Well, in determining whether or what the equity in the primary residence is, I mean, that takes into account your mortgage. The SBA looks at the current value of the property, and they discount, what's outstanding on that mortgage. So that does get taken into consideration, but in the same sense that the SBA is not going to count the value of your property towards your personal net worth, they're also not going to lower your personal net worth by the value of your mortgage. And I've even seen the SBA, take the position that, if you're underwater, and let's just say this is not your primary residence, but it's a secondary residence that will get counted towards your personal net worth. If you're underwater and essentially you owe more than the house is worth, the SBA is not going to lower your personal net worth, and what they're going to do instead is they're just going to zero it out.
And they could actually, and looking at the total asset test, even though you may have a property that's underwater, that could still be viewed as an asset that's counted against you for total asset purposes. One of the other questions we have here is, will you elaborate on the new mentor-protege rules, particularly concerning how they impact SDVOSB firms? At this point, there's really no new rules. We understand the rules are going to be issued, but we believe that if the rules are issued as we understand they should be, given what Congress mandated, service-disabled veteran-owned small businesses should be able to enter into joint ventures like those that 8A firms are able to enter into, because under the SBA's mentor-protege program, an 8A firm that's an eligible protege may joint venture with a large business mentor. And we understand that the SBA should be issuing rules like that for SDVOs, but that's also going to be the case for purposes of the other small businesses, women-owned small businesses, et cetera. So it does mean that there's going to be more competition with everyone playing by the same rules, but the competition is likely to be more fierce with firms participating in the mentor-protege program and going after work with large business mentors.
Okay, we have a question about, is there a limit on how much of your business can come from a single company where you have subcontracts? And this is actually a great question because one of the things that the SBA wants to see from an applicant firm is that they're not unduly reliant on one company for revenue. They want to see that you have a diversified clientele base. And if you look at the case law that's out there, the magic figure really at this, and it has been for some years now, is 70%. Meaning that if you go into the 8A application process and they're looking at your financials, your tax returns, and they're seeing that you're getting 70% or more of your revenue from a single company, then that could possibly, yeah, that's going to be an automatic reason for the SBA to deny.
Because they're going to find affiliation based upon the presumption that if you rely upon that much revenue from one source. Now keep in mind that there are exceptions to this rule. The SBA, what they do is there's two ways that they can basically disqualify you. One of them is by finding negative control. Another way is by finding that you're affiliated, and they should send that to an SBA office for a size determination. And if this company upon which you're relying for 70% of your revenue is a large business, you may then not be an eligible small business. But there is a body of case law that says that if you're a fairly new company, the SBA recognizes a fairly new company, may have to rely upon one particular client for its revenues. The problem for 8A companies is that they should not be viewed as new companies, or they may not be viewed because they've been in business for at least 2 years. But there is a body of case law that says, whether you're a new business, you could be in business up to 5 years and still be considered a new business. And so it's a somewhat complicated area, but we do recommend to our clients when they're applying for the program that if they have only one source of revenue, that they try to diversify that and try to bring the revenues down so that it doesn't look like it's coming 70% or even 60% from one source. I know it's easier said than done, but it does create a major red flag for us when we see an application.
Okay, I mean, it looks like we're running out of time, but there have been some questions about will this presentation be available, and we just wanted to let you know that to everyone who did register for the webinar, you will be sent a recording as well, and the slides are available on our website.
And for those of you who've asked us the other questions that we have here, we will try to get back to you, if not within the day, by the end of the week, so that we can answer those questions that we were not able to get to. We apologize, but we only have so much time. Thank you very much for attending. Take care. Bye-bye.